You're listening to 15 Minutes, where we feature community leaders sharing what the rest of us should know but likely don't. Hi, Chad Franson here, one of the hosts of Share Your Voice, where we talk with top-notch law firms and lawyers about what it takes to grow a successful law practice. This episode is brought to you by Gladiator Law Marketing, delivering tailor-made services to help you accomplish your objectives and maximize your growth potential. To have a successful marketing campaign and make sure you're getting the best ROI, your firm needs to have a better website and better content. Gladiator Law Marketing uses artificial intelligence, machine learning, and decades of experience to outperform the competition. To learn more, go to gladiatorlawmarketing.com, where you can schedule a free marketing consultation. My guest today is Scott Blackman, a partner at Booth Udall Fuller Intellectual Property Law. This firm specializes in various areas of intellectual property law, including patent, trade secret, trademark, and copyright. Scott brings decades of experience in patent law to the table. Throughout his career, he has formulated strategies that have led to desirable outcomes in negotiations. He's demonstrated a knack for explaining complex issues, often assisting examiners, judges, or opposition parties in understanding and aligning with his perspectives. Additionally, Scott's reputation in the field is evident from instances where his opponents have offered him roles post-negotiations and even times when opposing parties have sought his expertise for mediation in the absence of their own counsel. Notably, his approach to law emphasizes the importance of education throughout the entire legal process. Scott, thanks so much for joining me today. How are you?
Thank you very much. I'm good. How are you?
Good, thank you. What drove you to specialize in intellectual property law?
Well, my education was always in science and math, and my extracurricular activities were always in student government and working with lawyers and in politics. So I finally decided to try to combine the two. I have a master's in chemistry. I taught high school physics, and finally decided to try to combine that with law.
So when you first made that decision to go for law, what did you kind of envision yourself? How did you envision yourself? When you first made that choice, like, did you see yourself, arguing dramatically in front of a judge, or what did you think?
I wasn't sure where I would end up. I knew that there were several areas of law that were advantaged by having a science background, whether it's patent law, nuclear energy, medical malpractice, et cetera, the environmental. There's a lot of different options. My first summer as a law student, I worked at a small firm in Philadelphia, at a patent firm, and I really enjoyed it, and I've just kind of stuck with it ever since.
How has the field of patent law changed over the decades you've been involved?
Well, one of the things I enjoy most is the fact that we're always learning new technologies as well as developments in the law. When I started I graduated in '88. So when I started the Federal Circuit, which is effectively the Supreme Court of patent law, they were relatively new. So the court has developed over time. The law has developed. I clerked for one of the judges at the Federal Circuit, Judge Plager, who's a senior judge now, and it's been really interesting and it's been nice being a part of the development of the law and the court through the years.
Are there some particular challenges that you face when dealing with biotech and pharmaceutical patents?
Well, to me, the biggest challenge is that, in my mind, of course, it's one of those areas most foreign to a lay judge or jury. So the biggest challenge, especially in those areas, I think, is being able to explain the technology in an understandable way to someone who has no science or technology background.
I talked in your introduction about your success in negotiations and explaining complex issues. What kind of goes into that when you approach a negotiation? What's kind of your mindset and what goes into your strategy for having the outcome that you're looking for?
Well, the first thing is, most of the time in a negotiation, it's not a winner eat all, winner kill all situation. Usually there's some ongoing contemplated relationship between the parties. What a lot of lawyers don't keep in mind is that you really want to be able to set up. I mean, the negotiation is usually the beginning or a stage of the relationship. and you want to set the parties up so that they're dealing with each other in a reasonable way. They're both happy to be in the relationship. So you really don't want to. It's not a scorched earth situation. You want the situation. You want the result to be reasonable to both parties. Of course, you keep your client's interest at heart most, but it's in their interest too to start out on a good in a good relationship with the other side. So I try to keep things reasonable. To my experience, one of the most important things in this and other areas is just being prepared, knowing the facts, knowing the party's desires to the extent they're on the table already, and trying to figure out. My focus is basically trying to make the pie bigger and share the pie, get both sides to enjoy as much of what is priority to them as possible, and that way try to keep everybody happy.
So when you hear negotiations, you often hear, like, okay, you start on the extreme end, and then they'll start on the extreme end, and then there's like a tug of war. Is that your experience? Or are you? It sounds like it's a little different from your mindset.
Well, that's I think a very common experience. To me, I try to start out closer to the middle. I mean, it might be, I do try to, the first offer we put on the table typically leaves room for negotiation, but we want it to be reasonable. And in fact, there's been a couple times where, we've been negotiating contracts, for example, and the other side's attorney says, "Well, this is the way we think this point ought to be." And my response has been typically, "Well, to my experience, this is what's reasonable. And I'm not saying that your position is not, but can you help me understand how that's reasonable to both parties?" And on two different occasions, I've had the party on the other side end up negotiating with my client and me, and leaving their attorney out of further discussions, because both sides realize that we're trying to reach a reasonable approach and a reasonable agreement that satisfies and helps both parties.
I mentioned in your intro that education kind of plays a role for you. Can you explain that a little bit more?
Yes, well, I went to Philadelphia College of Pharmacy and Science. Later, it was known as University of Sciences in Philadelphia, and now it's part of St. Joe's. But I have 2 degrees in chemistry. I taught high school physics. My chemistry is from a pharmaceutical educational background, so it's especially helpful in understanding the technology. Especially when you're doing patent prosecution, it's helpful to have enough of a science background to understand the technology and be able to work with the inventors. If you're in a litigation situation, you're typically part of a bigger team and you're working with experts. So your own education is not as important. But when you're working with patent applications, it helps to have at least a foundational background to be able to understand the technology and the inventor's comments and desires.
Did you have a law degree when you taught high school physics?
Pardon? I'm sorry.
Did you have a law degree when you taught high school physics?
No, I taught high school physics before deciding to go to law school.
What or did your burgeoning negotiation skills help you in dealing with high school students?
I think what helped most with my high school students was I was pretty young at the time, so I think we for 2 reasons I think it helped a lot. First off, we just got along well. I was able to relate to them fairly easily, but also because it was because I was teaching for the first time, it was a situation where I was learning just a little bit before they were learning. So I've always thought that you cannot be as good of a teacher without learning. The learning part of it is really helpful. I think once you've taught the same thing for 5 or 10 or 20 years, it probably gets a little bit harder. But when you've just learned it yourself recently, it helps because you're basically facing the same issues as your students are now facing.
Yeah, that makes sense. Has your kind of your teaching background helped you? And I mentioned you kind of almost help examiners and judges understand complex patent issues. Has that background helped you in that regard?
Yes, I think it has. Any lawyer is trying to convince a judge or jury or patent examiner that their position is correct. And I think that having the teaching background helps me find different ways to try to explain things or give parallel situations to try to help them understand why they should agree with my position and not the opposite.
You you've been offered roles by or post negotiations by opposing parties. Can you talk about that a little bit? What does that scenario look like for you, and how do you handle it?
Well, the first time I was actually, I worked in the legal aid clinic at Cornell Law School. I was in law school, and we had one case for one of my clients, and it was a situation where um, the opponent was trying to quash the case, and we explained why they had been properly served and this and that. Anyway, so we won that issue before the court, and the case was moving forward. And afterwards, the other side offered me a job. Um, they liked. I mean, we were pretty thorough. We called the sheriff's officer who served the defendant, and had him testify that he knew who they were, and he knew that he served the right location. We called a postal employee to testify that it was the right address, and we submitted a telephone book to show that they were listed at the address where they were served. So I think just the thoroughness um, helped impress the other side as well.
Do you ever have a negotiation or a case where you start out thinking like, this is going to be quite a mountain to climb here, or I'm really up against it, and then you have kind of overcome that challenge? Or do most cases for you start out closer to the middle, like you said, you often like to start out?
I try to keep an open mind until I go through the background, go through the facts, and see exactly where we are, what the situation is. Um, Most people are reasonable, and most of the time there's some foundation for your client's desires and for their position. So a lot of times it's a matter of figuring out how best to put forth honestly and validly their position, and explain why their position is the correct one. A lot of times, one thing I've noticed through my career is a lot of lawyers don't take the time to be as thoroughly prepared in making an argument. They don't know the facts as well, and frankly, that's a lot of times half the battle. If you know the facts, if you know the situation, it makes it much easier to fully and thoroughly argue your client's position.
Yeah, I would imagine. How did you end up becoming a partner with your current firm? Is it Booth Udall and Fuller?
Yeah, Booth, Udall, and Fuller. Fuller is Rod Fuller. He and I worked together at a previous law firm at Winston and Strawn, and he left. I'm on the East Coast. I'm in the DC area, and Rod was first working out of New York and then came down to Washington. He left the East Coast for family reasons. So the main office for Booth, Udall, Fuller is out in Arizona, in Tempe, Arizona. We kept in touch through the years. He's kind of like a big little brother to me, and he called me once and asked about references for someone. They were looking for someone with my kind of background, and we got to talking about it. And next thing I know, I was joining them, rejoining Rod, and where I'm kind of the first part of the East Coast presence now for the firm, and so it's been a great reunion.
When you said you have a pharmacy degree?
I went to pharmacy school, but I have a chemistry degree, a bachelor's in chemistry, and a master's in medicinal chemistry, which is basically pharmaceutical organic chemistry.
So you have all kinds of education. What were your goals when you were kind of pursuing that route?
I wasn't sure. I thought maybe about going to medical school. I thought maybe about teaching. At one point, I was accepted into a PhD program for biophysical chemistry, and but I wasn't sure that I didn't want to start something like that without at least intending initially to finish it. So I decided I took the teaching job while I tried to figure out what I wanted to do in life. And that's when I finally decided I really wanted to try to combine science with law, and try to figure out how to combine my educational focus with my extracurricular interests.
How long did you end up teaching for?
Just 1 year. I
Okay.
was teaching at the Haverford School. That's the year I took my law school exam, and I figured I'd apply. My initial intent was to perhaps go to law school at night while I was teaching, but then I got into Cornell Law School, and it was it made sense to just go ahead and go full time.
Pretty rigorous. Did you does the way you have to think to be successful in terms of chemistry and things like that, has that helped you in terms of the way you have to think as an attorney or in the legal field?
It's helped tremendously. Legal thinking, legal logic, and scientific logic are very similar. I'm not flowery in my writing. I get to the point. It's almost like a recipe type of approach. But the thinking is very similar. I think that the science background helped me in law school and has helped a lot ever since as well.
Okay. Hey, I have one more question for you, but first, tell me how people can find out more about your firm.
Well, our website is boothudall.com, BOOTHUDALL.com. There's a lot of background information there. We try to help our clients in a way that, first off, helps protect them and tell them. One of my pet issues is that a lot of new and growing companies don't know enough to know what questions to ask early enough to protect themselves as thoroughly as possible. So we specialize basically in helping new and growing companies know what their options are, know how to protect themselves. And we do it in a way that's completely transparent all the way through. They know what the cost is going to be. There are no surprises. We work with them within their budget and figure out from their perspective what they want, how to best protect them, their businesses, their products.
Last question for you. As I mentioned, you have a very interesting kind of career journey, educational background. What keeps you passionate and engaged in your work after, decades in the field?
That was something I was worried about originally because I wasn't sure I could do anything for 10 or 20 or more years and not get bored and want to find something else. The advantage here is that we're always learning new science and technology as well as developments in the law. So, for example, through the years, I've worked on Polaroid film technology years ago. I've worked on fusion years ago when that first fizzled out, but we were one of the firms. The firm I was with at the time was one of the firms considered for some of that technology. I've worked with all kinds of biotechnology, pharmaceutical developments. So it's been really nice because I'm learning probably more on the science side than I am on the law side, but that keeps everything interesting.
Yeah, I would imagine. Hey, Scott, it's been great to talk to you. Thanks so much for your time today. I really appreciate it.
Same here. Thank you very much.
So long, everybody. Thanks for listening to 15 Minutes. Be sure to subscribe, and we'll see you next time.